Good afternoon and welcome to our webinar today here at the Society for the Rule of Law. Today's discussion is on the impeachment power and its relationship with the rule of law. My name is Greg Nunziata. I am the Executive Director of the Society. I joined the Society in this role earlier this year, and in a past life, I spent several years as an attorney and counsel and advisor to a number of United States senators and Senate committees. So I have a particular interest in this topic and the use and misuse and perhaps occasional abuse of congressional powers. I'm really delighted to be joined today by two prolific scholars and commentators on congressional doings and constitutional law. We have with us Keith Whittington, who is the William Nelson Cromwell Professor of Politics at Princeton University. He's the author of several books and scores of articles. And you can also follow him on Twitter at K.E. Whittington. He is a charter member of the Society for the Rule of Law. Also with us today is Professor Ilya Somin, a professor of law at George Mason University and the Kenneth Simon Chair of Constitutional Studies at the Cato Institute here in Washington. He is also widely published in book, article, and tweet form. You can follow him on Twitter at Ilya Somin. He too is a charter member of our society. Really delighted to have both of you gentlemen with us today. Look forward to this discussion. Before I dive in, or we dive in, I want to make a few housekeeping announcements at the top, and bear with me for just a few minutes. First, I want to remind everyone who's joining us today and listening, either today or in the recorded format later, that the Society for the Rule of Law is a membership organization devoted to the rule of law and constitutional values. And we very much appreciate our members. Our work is impossible without our members. And if you are not a member, I hope you will consider joining our organization today. There are a number of membership options that are open to not just lawyers, but law students and anybody who cares about the values that we share. Our website is the Society for the Rule of Law.org. You can also connect with us on social media platforms, including Twitter, YouTube, and LinkedIn. We will be hosting a live event later this month here in Washington on March 27th. Our guest will be John Bolton. Ambassador Bolton will join the chairman of our board, George Conway, in a conversation about the legal culture in America, the ambassador's experiences in government. We will have a link to that event in the chat, which you can see right there. Also, a special announcement related to one of our guests today. Professor Whittington has a book coming out on this very topic. The title of the book is The Impeachment Power, Law, Politics, and Purpose of an Extraordinary Constitutional Tool. It will be released freshly after the election to warn whoever wins. And it is available for pre-order now on Amazon and other platforms. So last thing I want to remind you all of before we get started, we will have a Q&A at the end of our discussion today. So if you have any questions that occur to you during the presentation or after, please drop them in the chat and I will sift through them and try to answer as many questions as I can. Please keep them brief so we can get through as many as possible. And with that, I would like to invite Professor Whittington to open us up with some of his thoughts about the impeachment power, its purpose, and use in America.
Great, thank you. I appreciate the opportunity to do this. It's an important topic, obviously, and one I think that we still don't understand as well as we should. And so I appreciate the opportunity to talk about it. And appreciate the work that the society is doing generally to bring these kinds of issues to greater attention. Somewhat strangely, I initially started writing about and became interested in impeachments when I was working on my dissertation quite some time ago. Which I found interesting for that particular purpose, but expected I would never write about it again. Little did I know at the time we appear to be entering into an age of impeachments in which impeachments have become quite common, very unusually so relative to American history. And I think that's partially a function, significantly a function of the way our partisan politics has played out and thus incentivized impeachments. And so I suspect we will continue to see impeachments coming along the horizon going forward. And so I think it becomes particularly important to think through what can and can't be accomplished by impeachments and why we ought to pay attention to them. The impeachment power, of course, was familiar to the founding generation, in part because of a British inheritance. It was a feature of parliamentary practice that they at least vaguely understood. They had carried it over into their early revolutionary state constitutions, and so it was commonplace across the states in the immediate aftermath of the American Revolution, and moreover was exercised to some degree by those state legislatures in the very early days of the Republic. But it entered into the federal constitution through the Philadelphia Convention when the framers began thinking about the presidency in particular, and began to really grapple with the concern that they were going to create a very powerful office, more powerful than existed elsewhere, certainly in the federal government up to that point, but really probably more powerful than anything existed in the states. And moreover, we're going to create a presidency with an extended and fixed term. A four-year term was extremely unusual in the period. It was a routine political motto of the period that one-year terms were the only thing that was something you could actually trust government officials with. And so the idea of empowering an important office for 4 years at a time without an electoral check seemed like a particularly risky thing to do. And so they began to grapple with the fact of what happens if something goes terribly wrong during that 4-year term before the next opportunity to hold the president to account through the electoral mechanism. And that's when they started grappling with something like an impeachment power that could be utilized in the meantime. It took quite a lot of debate about how such an impeachment power ought to be exercised, what the procedures ought to look like, who ought to have hold of it, what kind of standards ought to be deployed, and when the impeachment power can be used. And I'm sure we'll want to talk more about that. But I think the crucial thing to get on the table right away is that their concern is one of abuse of political office, ways in which the president, as well as other federal officers, but their initial concern is with the president, might behave in ways that are fundamentally incompatible with the nature of the office that they held, and might pose severe dangers to the future of the republic itself. And so some immediate action would be necessary to address. And the impeachment power was designed as a tool that could be available for Congress to use under those circumstances. This calls into question sort of many things about sort of the nature of that impeachment power, though. One thing that they do is they entrust the legislature with the authority to use the impeachment power. And this, I think, is not inconsequential, that the power to impeach in the first place, as the power to lodge accusations against a federal officer, is entrusted to the House. The judgment over whether or not those charges are adequate to justify the removal an officer is entrusted to the Senate. And while there's lots of suggestions that the Senate operates as a kind of court, it's a very special court in that sense, very different than other institutions. There's a reason why the founders did not entrust, for example, the U.S. Supreme Court or a body of federal judges to sit as an impeachment court. Instead, the Senate was entrusted with this authority in part because it was going to require the exercise of political judgment to determine, one, what kinds of actions were in fact fundamentally incompatible with the nature of the office being held. And that's not just simply a legal judgment, that's fundamentally a political judgment, a constitutional judgment about the nature of the office and the nature of the activities that an officer has engaged in. And then also requires a political judgment as to what to do about that fact. That an officer has behaved very badly in some sense and has created a situation that needs to be addressed. Is removal of that officer in the best interest of the country going forward? And is that an appropriate step to take? That's a judgment that the House has to think through in the first instance on whether or not to bring forward an impeachment in the first place, but it's also a judgment that the Senate has to engage in. And part of that challenge is not only thinking about sort of what kinds of actions might those officers engage in that are incompatible with their office, but also think about what other kinds of tools and remedies might be available for addressing the kinds of misbehavior that the officer has participated in. Impeachments are one kind of vehicle for remedying certain kinds of abuses, but they're not the only vehicle. And moreover, they're not the only vehicle available for abuses that we might think of as clearly impeachable. Even things that might justify an impeachment and removal might nonetheless be sufficiently remedied or better remedied by other means. So, for example, imagine a president who violates terms of the Constitution in various ways, or violates statutes, so is behaving in a fashion that is illegal. In fact, we see officers engage in such actions, and we've developed over time a fairly robust practice of judicial review to try to address those kinds of practices. So one thing the founders did not fully anticipate is the extent to which courts could help oversee how officers conducted themselves and could address instances in which officers behave badly in certain specific kinds of ways. I think it'd be very strange indeed if we thought that a president violating the Constitution was somehow not impeachable. And yet the first thing we turn to is not the impeachment power to address those kinds of concerns, but usually a lawsuit, and to exercise that power through the course of judicial review, in part because we find it to be a more efficient kind of practice. We find it more effective at addressing the problem at the heart of the controversy. There may be occasions in which we think that if a president is violating the Constitution or violating statutes, that's really a sign that that president is fundamentally unfit to hold the office and can't be trusted to continue to exercise powers going forward, such that the best remedy for that situation is to remove that person from office so they cannot continue to abuse power. But in many instances, we think it's possible for presidents and other officers to violate the law, to even violate the Constitution, and yet that can be adequately fixed through the process of judicial review, and you can continue to leave that officer in place because they can continue to do a good job and can in fact be trusted to use power over time. And so we constantly have to think about, when we're confronted with misbehavior by political officials, as to what's going to be the most appropriate mechanism for trying to resolve the thing that's in front of us. And if we want to pursue the impeachment power, what exactly are we trying to accomplish by doing so? Is this the best way to accomplish that goal? And is it even a possible thing that the impeachment power can help us accomplish? The impeachment power is a very big tool, but it's not always the right tool. And so trying to think carefully about why you're going down this path, what you're hoping to accomplish, and why this is going to be able to help you get there, I think is really a critical thing. And unfortunately, not something I think that our legislators have always thought through very carefully before they started running down the road of impeaching an officer and bringing them to a trial before the Senate.
Greg, I fear you're muted.
Of course I am. It wouldn't be a webinar without somebody doing that. May as well be me. Thank you, Professor Whittington, for those remarks. We have a lot to talk about there. But now I'd like to invite Professor Somin to give his opening comments. And Professor Somin.
Sure. Thank you to the Society for the important work it does, and for organizing today's event. And also thanks to Keith for his insightful remarks. I'm going to briefly go over what the Constitution says about impeachment, what it's supposed to be for. I'll talk a little about the current potential impeachment of Biden and the impeachment of DHS Secretary Mayorkas, which has actually been voted through. And then in the last part, I'll talk about how it is that sort of partisan differences and polarization have largely, though perhaps not completely, undermined the usefulness of impeachment, at least for high political officials. So if you look at the wording of the Constitution, Article 2, Section 4 indicates that the president, vice president, and all civil officers of the United States shall be removable from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. While this wording makes it seem like maybe you can only be impeached and removed if you are convicted of a crime. In fact, various scholars, including Keith, have shown that severe abuses of power that aren't necessarily crimes can also be impeachable. Some violations of the law, which are merely civil violations but not criminal, can be impeachable as well. And as Keith suggested, the main purpose of this was not as an additional enforcement of criminal law against government officials, but rather to prevent various kinds of severe abuses of power. Though exactly what makes it severe enough that impeachment is justified is debatable, and there can certainly be borderline cases. As a practical matter, and under current Supreme Court precedent, questions about what is a severe enough abuse of power to justify impeachment, and indeed nearly all other issues related to impeachment are under current Supreme Court precedent. In the case of Nixon versus United States, they are political questions that are left to the resolution of Congress. That includes the issue of what offenses are impeachable, also the issue of when the Senate holds a trial on impeachment, how that trial should be conducted, what the rules should be, what kind of evidence is presented, and so forth. So while there are constitutional arguments that can be made about this, under current Supreme Court precedent, the Supreme Court and other courts take a backseat and have almost no involvement. I think maybe that's a mistake. Maybe at least some aspects of the impeachment power should be justiciable, but the courts are unlikely to change that precedent anytime soon. We now in Congress actually have two ongoing impeachment processes. One is the long-running investigation by the Republican House of Joe Biden for possible corruption related to various activities by his son, Hunter Biden. So far, at least, it seems to me, maybe new evidence will emerge, but so far, at least, it seemed to me they haven't actually established any evidence that Joe Biden is guilty of corruption or that he's involved in his son's misdeeds in some way. There's plenty of evidence that Hunter Biden is a grifter, that he probably violated federal tax laws, possibly gun laws, perhaps some other laws, but they don't have the goods on Joe so far, which is why I think they have not chosen to actually vote on this yet. If they did have strong evidence, they would have voted the impeachment. I think that is not to say that Biden has not committed any acts which might be impeachable. I actually think maybe he has, but they're very different things from the ones that the Republicans in Congress are focusing on. One is his attempt to raid the Treasury to the tune of $430 billion in order to illegally forgive student loans. That strikes me as an enormous abuse of power, well worthy of at least consideration of impeachment. It is true the courts did eventually strike this down, but Biden, in addition to trying to engage in the abuse of power, also his administration tried to structure it in such a way that no one would have standing to challenge it in court. And it's only because they essentially got outmaneuvered by the state of Missouri, which turned out to have a state agency that could get standing in a kind of indirect way that that this plan failed, and so I think that might well be an impeachable offense. Even worse is what he did with Title 42 expulsions at the border, which I have argued elsewhere were illegal. He did this under a statute which said that you can block entry of people in order to prevent, quote, the introduction of disease into the United States. But he continued this for close to 2 years, long after the disease, COVID, already was introduced in the United States, and long after public health experts, including those in government, recognized that this was doing nothing to actually keep the disease out of the US. And he, like Donald Trump before him, who first established this policy, was continuing it for political reasons unrelated to the ostensible official rationale, which he almost certainly knew was false. Hundreds of thousands of people suffered severe harm because of this, including some who died as a result. That strikes me as a horrific abuse of power and illegal one that that deserves impeachment, but the Republicans would never do it because their only complaint about this policy is that it didn't continue even longer and didn't go even further. So, the things that are in the political arena as possible reason to impeach Biden are very different from the ones that he might actually deserve impeachment for. On the Mayorkas impeachment, with the DHS secretary, Keith has written an extensive Twitter thread which explains why this one is very dubious. I'll just make one or 2 points. First, the main thing for which he's impeached for is that he didn't, DHS under his direction didn't detain all the migrants that arguably the law says should be detained. However, it is in fact impossible to detain them all because there isn't the detention space and facilities. And no DHS secretary ever, including those under Trump, was actually able to detain all the people that law says should be detained. In addition, a basic power of the executive is enforcement discretion. And here, some exercise discretion is unavoidable. Some of the other things he's charged with are actually doing stuff that is legal and perfectly fine, like give parole to migrants fleeing horrific conditions. I've written elsewhere about why that's legal. And some things he's charged with are even things that are not within his authority at all to do, like he's charged with failing to reach an agreement with Mexico to continue the Remain in Mexico program. Even if that program was a good idea, the GHS secretary does not have the power to reach agreements with foreign governments. Maybe the Secretary of State does, or perhaps the president, but not Mr. Mayorkas. I think one could argue that Mayorkas does deserve impeachment because of his complicity with the Title 42 abuses that I mentioned earlier, but he certainly does not for the thing that he actually was impeached for. And it remains to be seen how the Senate will handle this impeachment. So far, they don't seem to be in much of a hurry to do anything about it. Some have talked about them possibly just tabling it and not even holding a trial. I'm not sure the Senate can constitutionally refuse to hold a trial. I think maybe they have to, but if they refuse to do so, there's probably nobody who can do much of anything about it, at least under current Supreme Court precedent. We also, of course, have had in recent years the 2 impeachments of Donald Trump. I think both were well justified. In the first case, he had tried to withhold aid from Ukraine for the purposes of getting the president of Ukraine to gather dirt for him on Hunter and Joe Biden. This, I think, is a usurpation of Congress's power of the purse. It is also actually a violation of criminal law, 18 U.S.C. 601, a law which says that you can't withhold government benefits from people or money that has been allocated to them by the government in order to pressure them into helping a campaign for public office, which is what Trump was doing. The second impeachment, the one arising from January 6th, I think everybody knows what that was about. If there was ever an impeachment in American history that was justified, it was that one. And the fact that the Senate nonetheless voted to acquit is an indication of how dysfunctional the impeachment system is. It's also perhaps a weakness of the requirement that you have to get 2/3 of the Senate to vote to convict. 57 senators, a large majority, did vote to convict in that case, but it was nowhere near enough to reach the 2/3 threshold. More generally, as I've suggested already, partisanship has severely undermined the utility of impeachment in modern times, at least, with respect to high-ranking officials who are at all, controversial partisan figures. It is almost impossible to get a 2/3 majority in the Senate in such cases against a president or other high official of their own party. I think the second Trump impeachment dramatically illustrates that. Indeed, in all of American history, only 8 senators have ever voted for the conviction of a president of their own party. 7 of those were Republican senators in Trump's second impeachment. The other was Mitt Romney, the one Republican senator who voted to convict on Trump's first impeachment. So partisanship plays a huge role in this, much more, I think, than the framers anticipated. Moreover, polarization makes it worse. It makes senators even more reluctant to break partisan connections and act for the broader public interest. In a period with less partisanship, when Richard Nixon was forced to resign, it is very likely that if he had not resigned, enough Republican senators would have voted to convict him to get to the 2/3. But in our era of extreme partisanship, that's almost inconceivable. That doesn't necessarily mean that impeachment is completely useless. Arguably, when somebody is impeached, but then not convicted, it might still dent their political standing somewhat. There's some evidence that happened to some degree with Trump after his second impeachment. Impeachments of lower level officials who abused their power might still be possible, though if there's bipartisan agreement on the abuse, often the lower level official might just be fired or might be subject to criminal prosecution and the like. And finally, I think impeachment has worked reasonably well when it comes to corrupt lower court federal judges. Keith will correct me if I have the data wrong, but I think something like 8 of them have been successfully impeached and convicted historically, and a number of others have been forced to resign under the threat of impeachment, precisely because the partisan stakes of these situations are relatively low. Impeachment can work reasonably well there. Sadly, at least in recent years, I think it is not working too well for purposes of dealing with abuses of power and illegality by high-level partisan officials. And on that note, I'll stop, but I very much look forward to discussions and questions.
Thank you. Thank you very much. First, before I lead off with some questions, I guess, Professor Whittington, do you have any direct responses to what Professor Somin just shared with us?
No, I think those are very important points to raise. I think the introduction of partisanship into the impeachment process is one the founders didn't fully anticipate. They were hoping there would not be the kind of political parties that we in fact have, and that creates all kinds of different incentives about how legislators are likely to behave as a consequence. I think one useful feature of the high bar in the Senate for an impeachment conviction, given the existence of political parties, is that you do have to reach across the aisle. And so you're only going to be able to convict and remove an officer if there is at least some level of bipartisan agreement that the kind of abuse we're seeing is severe enough to justify removal. And we might think that all things considered in a partisan world, that's the best way of proceeding, because otherwise you run a pretty serious risk of purely partisan impeachments and removals, which might be quite damaging on their own to the way the constitutional system functions. Whether the amount of bipartisanship that we currently require is too much relative to the impeachment power, I think may be an interesting question that one could imagine trying to lower the bar a little bit, at least. But I think some level of bipartisanship in removals probably makes sense, even in a world in which there's pretty strong incentives not to vote to remove people of your own party in the context of partisanship.
So I've lost lights in here. We'll see if they come back on. You can still see me at least.
We can still see you, yes.
I would like to, so I just put my cards on the table as a former congressional lawyer. I've got some bias towards Article 1 and have a kind of general belief that a lot of contemporary constitutional dysfunction flows from the weakness of Congress, contrary to sort of the original scheme. I think one of the, when I like to make a case for Congress's first amongst equals status, I like to mention the impeachment clause. Congress has this very unique, extraordinary power to reach into one of the other two branches and remove someone from office and disqualify them from holding office in the future. But it's hard to, maybe it's just evidence of my thesis about how off-kilter things are, that kind of really important power has been so eviscerated. I think you both touched on some reasons. I think, to me, the two biggest ones are this partisanship issue, which is maybe it's a slightly different way to say it. It's not just partisanship, but it's partisanship on top of or in the place of any institutional obligations. You don't see a lot of concerns for protecting congressional power outside of the immediate partisan scuffle in Congress, which is related, but maybe a slightly separate problem. And the other problem is this idea that impeachment must be tied to some sort of criminality. And I think, when we've talked about, I think every maybe successful impeachment conviction has been a judge, and most of those, though not all the earlier ones, at least the recent ones, have been very much tied to bribery and corruption and things we think of as criminal. So I guess really broad way of setting the first question is, how do we get there? I mean, I think the partisanship maybe we understand, but how did Congress come to believe that impeachment is really about criminality? I mean, I think even in the Trump matters, in both of them, really, I thought that the strongest case was about abuse of power or a violation of his oath, about abdication of his responsibilities, more so than criminality. But you saw Democrats in both cases trying to hook the charges to something conventionally criminal. And you saw, I don't think, any real effort to impeach, say, President Biden now on some of the like the student loan issue, or say President Obama on DACA and DAPA, and claiming the ability to give legal status to certain classes of folks here without authorization, without congressional support. Even though in both of those cases, you had presidents who said up front that I don't have the power to do this, and then they tried to do it. So how did we get here? Has it always been thus? Were earlier impeachments more about kind of these core claims of the balance of power? I guess I'll start with Professor Whittington on that.
Yeah, I don't think it's always been thus, but you could see this tendency very early on, and so it's always been the instinct of those officials who are under impeachment inquiry or have been impeached, who have not committed a crime, to argue that they can only be impeached on the basis of committing a crime, and so there's certainly an incentive on part of defendants in these contexts to try to shrink the scope of the impeachment power. And they tend to have supporters in Congress who go along with those kinds of arguments. There's also been, of course, people on the other side of that arguing that no, the impeachment power ought to be understood to be much broader than that. But we've seen from the very beginning these kinds of arguments that we ought to think about the impeachment power as being much more narrow. I think partially also we see over time a disinclination of Congress to pursue pure abuses of power, in part because they're going to be more controversial. It's if you can demonstrate that there's been a violation of a criminal statute, that takes some of the controversy out of the impeachment process. It becomes easier to demonstrate and justify. If instead you're arguing that power has been abused, that's going to be intrinsically a more controversial judgment. And Congress, I think, tends to want to shy away from it. In addition, I think we have discovered that there are other tools and remedies that tend to be available for addressing some of those. And so it's let Congress off the hook to some degree in having to respond to it. So one reason why we find ourselves primarily impeaching lower court judges is because they have life tenure and no one else can fire them except for Congress. And so if a federal judge really decides to dig in and refuse to resign, there's no choice but for Congress to step up and actually address that situation. By contrast, you could imagine a world in which there were lots of impeachment of cabinet members or sub-cabinet officials who are civil officers of the United States and are subject to the impeachment power. But instead, what we find is that cabinet members and others who find themselves in a great deal of controversy and are dragging down the administration get fired by the president. And so for the most part, Congress doesn't need to take action against those kind of officials because there are other means available, including in this case through presidential action, to remove those kinds of officials. And so we wind up really narrowing down the set of people we target, the kinds of actions that we target. Congress wants to avoid certain kinds of controversies. And even in the context of about impeachments as a investigation of criminal activities, Congress has really preferred to outsource the criminal investigation. So you rely on prosecutors to bring charges against lower judges, for example, and then only after those prosecutors have done the work will Congress get involved. You rely on independent counsels to bring the charges against presidents, and then only after that investigative work has been done does Congress get involved. So Congress has really chosen to think that they would prefer to sit back, not use their own time and energy and resources on these kinds of issues, and try to leave it as much as possible to others to deal with instead.
Yeah, so on this, I want to push back a little bit against the notion that impeachment has been limited in recent times to cases where crimes have been committed or there are allegations that there have been. The impeachment of Mayorkas right now, Keith can correct me if I have this wrong, but as I understand it, none of the articles of impeachment against him are allegations that he has committed a crime. Someone allegedly did stuff that was illegal in the sense that he exceeded his authority or whatnot, but there's no allegation of a crime. Similarly, in the first Trump impeachment, while I and some other commentators, i.e. people who are not members of Congress, argued that Trump had committed a crime in violation of 18 USC section 601. That claim is notable by its absence from the other actual articles of impeachment, which has focused on abuse of power. Even in the second Trump impeachment, there is not an allegation of a violation of criminal law in the article of impeachment. Perhaps it could be interpreted that way. So impeachments for abuse of power or for non-criminal activity are very much with us in recent times. Whether they have been effective or not, is debatable. Obviously, there was not a conviction in that Trump impeachment. I'm going to go on a limb and say that Mayorkas also will almost certainly not be convicted. Indeed, it may even be that the Senate won't even hold a trial. We'll see if they do or not. But modern practice does engage in impeachments for non-criminal activity. There's an argument that it shouldn't, and you can make it sort of from just the sort of plain text. But if you look at the history and original meaning, it seems clear that at least some non-criminal types of actions can be impeached. And there indeed is a long history of impeaching people for them, albeit not always, and in most cases, very successfully in terms of getting convictions.
What
Yeah, it
about
is worth noting that the House frequently does impeach based on non-criminal activities, and sometimes the result is the officer will resign, and so you don't get to the point of a trial. Sometimes it's the case that the Senate doesn't convict in those kind of situations, but it's also been the case over the course of American history where the Senate has convicted when there's been no allegations of criminal violations at all. And so I think we have had a tendency to lean toward criminal violations, but it certainly is not exclusively so. And the House certainly has never accepted that that's been the appropriate standard for when you can use the impeachment power.
Sure, but it just did seem to me there's kind of a gravitational pull to criminal-like concepts, even if we're not talking about criminality. We got very hung up in the first impeachment on whether there's a quid pro quo, for instance. But let's just talk about in a second, Professor Somin, you mentioned the question about whether or not there'll be a trial in the Senate of Mayorkas, and I understand that I think that formally what's happening is the House is holding charges because the Senate will have to, once they're presented, will have to begin some kind of process. Do you have an understanding of what is required by the Constitution? Must there be some form of process or trial?
So I have an understanding, although obviously whether the House and the Senate hold the same view is a different question. In my view, once the articles of impeachment have been submitted to the Senate, they do have to hold a trial, and the procedure has to have some kind of minimal due process that could be viewed as a trial in the Anglo-American legal tradition. It doesn't necessarily have to have all the safeguards of a criminal trial or use the sorts of rules of evidence that a criminal trial would use. But to my mind, the word try does mean something, and therefore they can't do things like just hold no presentation of evidence at all or no proceedings at all. They can't summarily dismiss the charges or summarily vote to convict. They can't roll dice or use Pagon trail to determine whether a person should be convicted and so on. However, what I think matters less than the Supreme Court's decision in Nixon versus United States, this is not President Nixon, this is Judge Walter Nixon, a lower court judge who in the 1990s was impeached and convicted, I think, for taking bribes, if I remember correctly. And the trial that was held in the Senate was actually conducted only by a subset of senators actually sat and heard the evidence. I think I forget exactly how many, but it was something like 10 or 15 maybe. And then they presented their findings to full Senate, which voted on it. Judge Nixon said, well, that's not a trial in front of the full Senate. And he filed a lawsuit challenging the constitutionality of his conviction. The Supreme Court not only upheld his conviction, but also the majority ruled that all matters related to impeachment trials, and by extension, other aspects of impeachment are non-justiciable political questions. So at least in principle, therefore, they could just choose not to hold a trial or to roll dice or use fortune telling or whatever they want. I agree more with the concurring opinion, I think, by Justice White, where he said the meaning of the word try is justiciable, and there has to be at least some kind of minimally trial-like procedures. But obviously, that view didn't prevail. And it's unlikely that the Supreme Court is going to overturn that precedent anytime soon, because I suspect they like not being involved in impeachment issues, and they probably prefer that. And therefore, as a practical matter, the Senate can do almost anything it wants with this. And there has been some talk of just not having a trial, in some ways summarily rejecting the articles of impeachment in this case. Whether the Senate Democratic leadership will ultimately decide to do that, I don't know.
So there's been, as I think everybody understands, sort of the House impeaches, which is something like an indictment, and the Senate tries and convicts. Just talking about the Senate process, what about the House process? There's been a fair amount of argument, both in the current Biden inquiry and during the Trump processes, about whether the full House, must authorize an impeachment inquiry. I guess I could ask Professor Whittington, is there any basis for that in the Constitution or historically? And then whatever the answer is to that, is there something magic that happens with an impeachment inquiry that gives Congress more oversight power than it would already have, which is a related but somewhat distinct question?
So I think constitutionally speaking, there's no process required at all. The House can really pursue an impeachment by whatever mechanism they want, including the possibility that somebody could just motion to impeach on the floor, and the House could immediately vote to impeach, and then you're done and move forward with no further investigation required. And you can imagine circumstances where, moreover, that would actually be justifiable. So if an officer behaved in a way that was obviously impeachable, and they did it in full view of the public, such that there was no need to actually carry out an elaborate investigation and try to figure out what the underlying facts are. That's not true of many of the kind of impeachment inquiries that the House, in fact, pursues. But if you were faced with that kind of situation, there's no real reason why you need an elaborate process in order to get there. What the House ultimately does need to be able to do is actually draft articles of impeachment that can get a majority vote from the House, such that they can deliver it to the Senate and provide the basis for a prosecution. And moreover, they need to be able to assemble the evidence that they'll have to present in trial. And so there's pragmatic reasons to want to have more of a process than that, just in order to help support the House itself in developing the necessary tools it's going to need to be able to prosecute successfully an impeachment in the Senate. And moreover, there may be occasions in which you want, for example, to hear from the officer in order to know maybe there's a good explanation or excuse or the like in order to justify not moving forward with an impeachment. And the House ought to be open to hearing that kind of argument. Under the House rules, over time, there's been a lot of changes about what kinds of investigations committees can engage in, for example. And so there was a time in which the House floor was not very trusting of House committees on launching their own investigations, and really required the House committees to go to the floor in order to get authorization in order to pursue investigations. That's not true under current House rules. There's elaborate authority for the House committees to engage in their own investigative processes. They have standing authority and resources in order to do that. That doesn't require separate votes. And that's true in the impeachment context as well. And moreover, I think there's nothing particularly magical about authorizing impeachment vote, nor do we want it there necessarily to be anything magical. I think part of what what the House's authority in conducting an impeachment inquiry or pursuing an impeachment should be recognized as very constitutionally consequential. The House has extraordinary authority to look into the workings of the judiciary branch and the executive branch in order to determine whether or not an individual has misbehaved and move forward. And even George Washington recognized that some claims of executive privilege, for example, that would be appropriate in another context, would not be appropriate in the context of an impeachment inquiry. And so one thing that is true for an officer who might be subject to an impeachment ought to know is, are you asking because you're pursuing some legislative business, or are you asking because you're pursuing an impeachment? Because the kind of response that an officer might give might well be different depending on those circumstances, because the kind of constitutional authority the House is bringing to the table is more expansive and different in the case of an impeachment inquiry. Obviously, under current circumstances, officers resist that kind of distinction. The Trump administration very much pushed back against that kind of claim. But so I think there's good pragmatic reasons why the House ought to do more when it's contemplating an impeachment. But from a purely constitutional perspective, I think there's not much required.
Two quick questions on timing. You can answer briefly. Because this in the Trump matter, we had a debate about whether the Senate could try a former officer on impeachment charge. And with respect to the Biden inquiry, it appears to be focused on behavior that he's alleged to have committed while he was vice president, so in a previous office. Can you impeach and convict and remove someone for charges for behavior prior to assuming this office? And can you convict a previous office holder? Do either of you have strong instincts on either of those questions?
Yeah. So I definitely think you can impeach and convict someone after they have left office. This was debated during the second Trump impeachment. I think that for two reasons. One is textually, in addition to removal from office, which you might think is sort of superfluous if the person is out of office anyway, the person, if convicted, can also be barred from further office holding, and that is a sanction that can continue to be imposed, and there's precedent for doing it, and there's good reason sort of textually to allow that. In addition, if you look at British impeachments that form the basis for the founders' understanding of this power, the impeachment of Clive, the former British governor of India, actually took place after he was out of office, and that was the best known, Keith can correct me if I'm wrong, but this is the best known British impeachment precedent that was familiar to all the founders. So if it was possible with Clive, it should be possible with office holders in the US, and that was, I think, the dominant understanding at the time of the founding. Brian Kalt, a leading scholar on this, has written some excellent work explaining this. On the issue of offenses committed in a previous position, such as with Biden, when he was vice president, I think probably the answer is you can impeach for that as well, because that's still something that he did when he was in an office. So if you can impeach after he's left office, and it follows you can impeach after he's left the office that he was in before, but then came into another office. I'm not so sure when it comes to the issue of impeaching somebody for things they did when they were out of relevant federal office entirely. And indeed, much of what we're talking about with possible contacts or possible involvement of Jill Biden and Hunter Biden's business activities was things that he did, during the Trump administration. And that, I think, it's much more questionable that that's impeachable. Though I also think it's also very questionable that sort of that was a crime or an abuse of power or any kind of serious problem at all, given Joe Biden during that time was a private citizen, and yes, he was an unusually influential private citizen as a former VP. He had the ability to open various doors that sort of an ordinary schmuck would not be able to open. But it's the whole. But it's questionable whether anything he did at that point with regard to his son's business, even if he did lobby to help his son's business in various ways, that was somehow an abuse of power or a crime or a civil violation and the like. So that, I think, is a tougher gray area. On the other hand, you might say, what if during that period he had committed murder and they only found out about it after he became president? Could he be impeached for that? I think that would pose a difficult hypothetical, and I'm not sure, what to do with that.
I have a good question from one of our viewers, which is, does double jeopardy apply to impeachment?
So there's two versions of the double jeopardy question. One is the one that former President Trump is making now, which is to say, because there were acts associated with a prior impeachment, can he now be brought into the court system for potential crimes related to that? I think the answer there is clearly he can. So double jeopardy does not attach in that sense. And one way of thinking about that is that the impeachment power is primarily a political power addressing political acts. There may be underlying criminal conduct that is associated with those political acts, but that underlying criminal conduct is addressable through ordinary criminal courts, whereas the political abuses are addressable through the impeachment power. I think there's another potential secondary version of this, which is to say, if you've been impeached for a set of actions once, can you be impeached for the same actions again? So, for example, if President Trump gets reelected, can the Democrats in Congress bring an impeachment based on the exact same actions that he was already impeached for once before? Or imagine a president was impeached for a set of actions, acquitted, and then there's a midterm election, the composition of Congress changes, and Congress wants to roll the dice and try again with a second and try bite at that apple, impeach again for the exact same offenses, but bring them for example, a different constituted Senate that might be more amenable to the impeachment charges. I think that's a difficult hypothetical, actually. I don't think there's a good reason to think that it's necessarily ruled out by the Constitution, or that our double jeopardy principles ought to necessarily exclude it. But I think it's probably worth thinking harder about if we found ourselves in that kind of situation.
Another audience question I think is interesting is, do we worry about, in increasingly partisan times, beginning to see routine impeachments of judges or justices based on their rulings from the bench? If so, why or why not? And are there any precedents of those kinds of impeachment of judges? I certainly, well, I don't remember, but I've read of the impeach Earl Warren campaign. But so please share your thoughts, whoever, Ilya, I suppose.
Yeah. So I think it could happen. The likelihood of conviction is very low because the same partisanship would ensure that you won't get 67 senators convicting the person, but it could happen. There has been talk among some Democrats about possibly trying to impeach Clarence Thomas or Alito for possible ethics violations, taking gifts from from influential people and the like, or in Thomas's case for hearing cases related to the January 6th issues when his wife was active in some ways in the effort to try to keep Trump in power. I don't think those ideas have gone very far, and obviously nothing will happen so long as the Republicans have control of the House. So I think it is possible that you will see some attempts at judicial impeachment. There is precedent in the sense of the impeach Earl Warren campaign, which never got to an actual impeachment, but it had some political momentum. Justice Samuel Chase, I'm sorry, of the Supreme Court in the early Republic, was in fact impeached, though it was more for sort of bad behavior on the bench and the like than for sort of the specific outcomes of rulings. But you could argue if you believe, and I do believe, that severe abuses of power can justify impeachment, you could argue that sufficiently awful substantive judicial rulings could justify it. What would count as sufficiently awful or sufficiently abusive can be debated, just like you can debate it in the case of executive officials. What would be a sufficiently bad behavior to be an abuse of power? As a practical matter, I do not expect that such impeachments are going to get very far. And unlike in the case of an executive branch official, if the justice or the judge gets acquitted, even if as a result their popularity is dented in some way, that doesn't affect them as much. So of course, they don't run for elected office. So, even if Clarence Thomas's or some other Supreme Court justice's approval rating goes down or whatnot, he might not care, because in his mind, he might just say, well, these are partisans of the other side, going after me, and it's all political, and I don't feel like I'm in any way going to change my behavior because there's no electoral reason to do so, and I substantively think that I did nothing wrong.
I think that's all right. I would just, it may be an opportunity though as well to sort of say when impeachments are inappropriate, constitutionally speaking, when things don't arise to the level of high crimes and misdemeanors. I think Ilya is right to say it's possible for judges to abuse their power, just like it's possible for executive branch officials to abuse their power. And certain kinds of egregious decision making by judges may constitute that kind of abuse of power, such that they would be subject appropriately to the impeachment power. But the founders recognized, and it's certainly been part of the tradition of the American constitutional system, to think that it's inappropriate outside the bounds of the constitutional impeachment power to bring people up on charges that simply amount to ordinary political disputes, policy errors, policy disagreements, simple incompetence or maladministration by executive branch officials, et cetera, have all been viewed as outside the scope of the impeachment power, that they should be remedied by other means, but should not rise to the level of an impeachment as such. And so we might think that ordinary disagreements, and this is part of what Samuel Chase argued in his impeachment trial in the early republic, is I may have made legal errors in my judgments in some of these cases, but they're ordinary legal errors. They're not genuine abuses of power, and as a consequence, I shouldn't be impeached and convicted on the basis of those. And so undoubtedly, there's some gray areas there as to when do ordinary political disagreements run into actual being abuses. But in principle, I think we all recognize that it's itself an abuse of the impeachment power to want to bring forward impeachment charges on the basis of things that are really ordinary political disagreements that we think ought to be resolved through elections, for example.
Yeah, and I agree, and certainly there's some gray area with both judges and also executive officials of sort of when do ordinary disagreements end, or sort of reasonable mistakes on legal issues even end, and when sort of does an abuse of power begin. I think there are some which are so egregious, like the Title 42 matter I described earlier, that they cross over into that territory. On the other hand, there are other ones which clearly don't, and there might be some which are sort of fuzzy in the middle and, maybe hard to tell.
So one of the, one of our other questions was if we accept Ilya's definition of abuse of power as a basis for impeachment, what was the last president that wouldn't have committed some such reasonable ground for impeachment? And if me again being a partisan of Congress, I feel like maybe all of them or most of them have at least some fact pattern that would have been impeachable. There's a question of discretion and prudence. But what puzzles me a bit is this is the first impeachment we've had of a cabinet secretary in something like 150 years. I understand that removing a president is traumatic, and especially in an era of popularly elected presidents, there's a reluctance to do that. I'm curious as to why Congress hasn't kind of routinely brought abuse of power charges against the most closely implicated cabinet secretary for things like your case of Title 42.
So there's really sort of two questions there. One is, has any modern president not committed these abuses of power? I think probably the answer that Greg gave is correct, and there may not have been, because there's a tendency to over-accumulate and abuse powers in the executive branch, in part because of the vast growth of government, which I also decry over the last 100 years. And therefore, one of the reasons why I favor this kind of impeachment, if it were more feasible, is that we have to rein in that abuse. And, we have here, as in many instances, type 1 errors and type 2 errors. Type 1 errors are sort of allowing abuses, to pass unscathed and unchallenged, and the other is sort of over constraining the executive. I think we're way into the territory where type 1 errors, allowing abuses to go unchecked, is a vastly more serious problem than type 2 sort of excessive constraints on legitimate uses of power, and therefore, I'm willing to take some risk of type 2 errors to rein in the massive, egregious type 1 errors that we have rampant all over the place. On why cabinet secretaries have not been impeached much over the last 150 years. Keith probably knows the history better than I do, but I suspect it's because, as Keith suggested earlier, that when cabinet secretaries are really vulnerable or do things that are seem corrupt or seriously unpopular, they will usually just get removed or pressured into resigning, or in some cases, criminal charges will even be filed, as has happened a few times, and therefore, impeachment was not seen as really necessary, given that there are these other simpler ways of dealing with them. But maybe, it would be desirable to have more impeachments of them. And one can imagine if the Mayorkas impeachment is regarded as politically successful, one can imagine future Congresses as imitating it, even if he doesn't get convicted. In principle, you can imagine the Republicans getting a political boost from it, which I think is in some ways the real purpose of it. So far, that political boost has not happened, and it doesn't seem like the Republicans have won over anybody by impeaching him that wasn't already supportive of their cause, either on the specific immigration issues involved or more generally in the election campaign that's going on now. But if the Mayorkas impeachment or another one like it starts to seem like it's a political asset, then I can well imagine more of them happening.
Well, we are, I see, at about the hour, although there's plenty more to talk about. I apologize to the questioners that I didn't get to. If either of you have a point that you wanted to make or a closing thought you'd like to share, now would be a great time.
We covered a lot of ground. As you say, there's often more to talk about, but I think this is a good place to wrap up. And again, I appreciate the opportunity to talk about this. Unfortunately, I think we're going to have occasions to talk about impeachment power more in the future.
That is very likely true.
Well, thank you both. I sincerely, personally, I'm very much enjoyed this conversation. I hope our viewers did as well. Thank you on behalf of the Society for the Rule of Law. For those of you who tuned in today or tune in to our recording in the future, please consider joining the Society at our website, societyfortheruleoflaw.org. Connect with us on LinkedIn, Twitter, and YouTube. Continue this conversation. We're hoping to build an ever-growing community of Americans, lawyers and not, who are concerned about these types of fundamental issues of the rule of law and constitutional values in America. Please also don't forget to pre-order Professor Whittington's excellent book, I'm sure. I look forward to reading it, available on Amazon now. And remember to register if you're in DC for our evening event with Ambassador Bolton and George Conway here in Washington on March 27th. All the information is on our website. It is now the hour. Thank you both very much, gentlemen. I really appreciated this and look forward to continuing this conversation with you and all of our members. Thank you.